Welcome to Constitutional Defenders, where we discuss important issues and cases related to criminal defense and how criminal defense attorneys handle these cases on a daily basis. Today, we'll be speaking with Marla Mitchell-Cichon, who was the attorney that helped release Ledura Watkins. Ledura Watkins was wrongfully convicted of murder in 1976, due largely in part to scientifically invalid evidence. Welcome to Episode 4. Welcome back. Today we have, as usual, Takura and Mary. Hi, Mary. Hi, Takura.
Hi, Lizzie.
Hey, Lizzie.
How you guys doing?
Good.
Yeah.
Living the dream.
Living the dream. Enjoying the last few nice days before. I know, poor Takura.
sad.
He's always freezing.
So sad.
I know.
Well, I love winter, as you know, so I'm excited.
Me too, because I'm a sweater.
I mean-
So, I like the cold. Less sweating involved. So, Mary, who do we have today?
We're very fortunate to have Marla Mitchell-Cichon with us today. Marla runs the Western Michigan University Thomas M. Cooley Law School Innocence Project. That's a really long name, Marla.
We shorten that.
Right, one of the first things you should put on your to-do list is shortening that name. But Marla and her team were instrumental in exonerating Ledura Watkins, who spent almost 42 years in prison for a crime he did not commit. And Ledura is an amazing inspiration to all of us about how we should be living our lives with gratitude. Marla's going to talk to us today about how they exonerated him and all the inside scoop on that case. So welcome, Marla. We're thrilled to have you here.
Thank you, and you can say Cooley Law School Innocence Project.
Okay, great. Good. There you go.
Marvelous,
Cooley Law School
marvelous.
Innocence Project.
Yes.
That's as
Great.
short as I can make it.
Right. That'll save us probably 5 minutes. So, yeah. Great. So tell us, Marla, about Ledura Watkins. He spent almost 42 years in prison for a murder he did not commit. Tell us how he was charged, what the supposed evidence was against him. Give us an overview.
Yes. A school teacher in Detroit was murdered in September of 1975. And shortly after her murder, a man by the name of Travis Herndon walked into a Highland Police Department and implicated Ledura Watkins. So that was how the ball got rolling, so to speak. Mr. Herndon was immunized. He received immunity for the crime and became the key witness against Mr. Watkins.
Did Herndon and Watkins have any sort of relationship where he would point the finger at Watkins?
They were acquaintances, and there actually had been a falling out between the two of them. Years later, Herndon admitted that he had broken into Watkins' family's home, and Herndon also believed that Watkins had shot a gun at him at one point, but it actually had not been Watkins. So at the time that he implicated Watkins was sort of an easy fall for him.
Did he just walk in off the street, or were the police looking at Herndon for other charges?
No, the interesting piece about that is that what we believe today is that the actual perpetrator was Herndon and a Highland Park police officer. And Herndon...
Intriguing.
Jeez, right.
Tell us about that.
Yes, so Herndon, the police officer worked in the Highland Park school system, and both Watkins and Herndon knew him. The police officer was believed to have been involved in drug dealing. So this woman who was killed, who was a school teacher in the Detroit school system, was a known drug dealer.
By chance, did she teach chemistry?
I don't know what she taught.
It's a little
Okay.
Breaking Bad reference. That's right. Science.
So what we believe is that Herndon realized, because he was a participant in the murder with this police officer, I think he was getting nervous. And so he decided to implicate Watkins in the murder, which solved a couple of problems for Herndon. One is he implicated Watkins, in fact, his first statement was Watkins acted alone. That statement was actually never turned over until 2009.
Wow. So from 1975 to 2009, was your team instrumental in getting that?
Mr. Watkins had many attorneys and assistants over the years. I believe that information came to light with the assistance of another attorney who had continuously FOIA'd for the police file, and then during another post-conviction proceeding asked for an order for the file to be turned over. And then that file appeared in 2009, and it had about 325 pages of documents that the defense had never seen.
Wow.
But it was only through a lawyer that he got that. I mean, it was never turned over to him originally, and then my guess is Watkins tried to fight his case, and it took that many years to actually get that statement.
Yes, and frankly, Mary, that happens in our office where we send a Freedom of Information Act, we request an entire file, and then we don't get the entire file. And we have cases that we work on in our office now where we send Freedom of Information requests multiple times and often get different or additional information.
We hear you. We have a case right now at the Conviction Integrity Unit in Wayne County, and we sent so many FOIAs, just dozens and dozens of them. We would get a denial one day and then get a document 2 days later. We've, again, been denied, and then we send it again and get part of a file. What's interesting on this case is we had been told for years that, and the client had, since 1994, there were no forensics. What happened? What did we just find out this year? There were forensics. Right. There was DNA, which is being tested right now. And the Cooley Innocence Project is involved with that through the Conviction Integrity Unit. Lori Montgomery has been just an amazing help. But it's crazy that you would think that there's an easy process to get information, and there's not.
It's taken years.
Right. Absolutely years for Lucino. 100%. That's our client.
Yes. And in fact, in Mr. Watkins' case, at one stage in the search for these documents, he or his attorney were informed that the file had likely been destroyed. And, of course, the file was ultimately found.
That's wild. And hats off to them for not giving up.
Right, for sure.
Yes, and that's, ironically, and we'll get into this, is, we jumped into the case primarily because of Mr. Watkins' own legal efforts on his own. He actually won the reversal from the Michigan Supreme Court.
Did he?
Yes.
Awesome. Did he argue it, or was it just on the pleadings alone?
No, what happened is he actually had an attorney who filed what would have been considered a second 6500 motion. And when he was denied relief, he went to the Court of Appeals, and I believe at that point he didn't have an attorney, and they denied review because it's a discretionary review. And then he appealed to the Michigan Supreme Court, and to the Supreme Court's credit, they summarily reversed the denial of the 6500 motion and sent it back to the circuit court in Detroit to answer the questions. There were basically three issues that he raised, and that is when we jumped in.
What were his three issues?
He raised ineffective assistance of counsel. He indirectly, well, he raised the Brady claim because there was a number of, while there were a number of documents in that file, there were maybe a handful of documents that were critically material to Mr. Watkins' defense. So he was raising the Brady claim. And then indirectly, he was raising the claim that he actually received relief on, which was the hair analysis that was done in the case.
Oh, junk science.
With the file, I'm fascinated by this. We hear a lot about a miscellaneous file. Do we know why this wasn't turned over? I mean, was there ever a response from the police or the prosecutor as to why this wasn't turned over in the 70s and why it took so long to turn it over?
No, there was never an explanation. So, again, multiple times throughout the years, either Mr. Watkins through assistance, because in Michigan, as we all know, prisoners cannot access the Freedom of Information Act. So through organizations that assisted him, attorneys that assisted him, and then eventually it was the court ordering the file to be turned over.
Tell us about the hair analysis that he received relief on. I mean, as Takura said, that is junk science, and we know that. Tell us about what that was like and what the process was.
Yes, in fact, if I could go back, in 1975, the key evidence against him was Travis Herndon, who you've heard a little bit about, and the hair comparison evidence. His attorney filed a motion to suppress in 1975, arguing that the hair comparison evidence was not scientific, but the judge allowed the evidence to be introduced, and obviously the jury heard it.
Good for that lawyer for
Yes,
doing that
exactly.
in the 70s. Good for him.
Yes, and then on appeal, the hair evidence was challenged from the perspective, again, of it should never have been admitted, and that claim was denied. Then on appeal to the Michigan Supreme Court, there was a dissenting opinion by Judge Levin saying that the science was junk, and that was in like 1977, which is crazy. So now fast forward, right? In some fashion or another, Mr. Watkins was challenging the hair evidence, but the focus post-conviction was on Herndon's recantation, because he recanted his implication of Watkins. But what ends up releasing Mr. Watkins was the unscientific methods used in comparing hair collected from the crime scene.
Because wasn't it they took, like, they compared the hair from the crime scene and then one of his and said, like, in a certain amount of spots, they look the same?
That's a good summary. I actually joke in my office that I can do hair comparison.
Yeah.
Right.
So like if I could pick up two hairs.
Mine and yours.
Yes. There's significant problems with hair comparison, and unfortunately it's been used in the criminal justice system along with other forensic practices that aren't scientific, such as bite mark comparison.
I mean,
So
to be clear, is it anything more than a person looking at a microphone, looking under, a microscope at two hairs and maybe it looks like this, maybe not?
it's really not. It's really not more than that. The FBI actually trained individuals and trained individuals to say that there are certain points of comparison, but what we know now is that that's a completely unscientific approach to evidence. So the FBI came out publicly in, I believe it was 2013, and disavowed much. They didn't disavow hair comparison. They disavowed the way in which FBI-trained analysts were testifying. Analysts were overstating their findings. So the findings or the testimony would typically be, this hair is coming from a single source or a particular person, the term scientific certainty, someone, even to exclude someone from a hair is technically not scientifically possible. And in Mr. Watkins' case, the crime scene was actually compromised. Individuals came onto the crime scene before the police did. There was a medical personnel type of person who came onto the scene and actually interacted with the body of the victim. And as it turns out, the hairs that were compared, and there were two hairs that were damaging to Mr. Watkins. One was the hair that you referenced, which was a hair collected near the pants of the victim, was compared to Watkins and determined to be similar. And then another hair, out of literally hundreds of hairs collected at the crime scene, was microscopically similar to Travis Herndon. And those two facts in significantly big black quotes, became the basis, the independent basis from Travis Herndon, placing not only Watkins, but Herndon at the crime scene. Now, admittedly, Travis Herndon admitted he was there. But again, let's go back to 1975, 76. We're on the jury. We believe this is scientific evidence. So this not only placed Ledura Watkins at the crime scene, which was the only arguably credible at the time evidence, and it placed Herndon, which bolstered Herndon's credibility that he was there and that he could actually describe what happened. And unfortunately, it took almost 42 years, and many things that happened in this case had happened completely outside of Mr. Watkins' case. This disavowing by the FBI really created the platform for saying that this scientific, that what we've discovered, newly discovered, even though we've really known it since 1975, right?
Justice Levin knew it right in the 70s.
Yes,
Right.
but to get legal relief, we argue that these new findings by the FBI, and we also had an affidavit from an independent expert who went through the lab reports, the suppression hearing testimony, and the trial testimony, and pointed out numerous times in which two analysts overstated their findings according to the FBI standards. And that was what led to Mr. Watkins' exoneration. But obviously there was a lot more to that.
You talked about Herndon ultimately testifying that he was at the scene. His original statement is Watkins did it alone. Then that statement is never turned over to the defense. Ultimately, his statement evolves to, I was there with Watkins, and Watkins committed the murder, and he got immunity for the murder. Is that the landscape?
That's correct. And then Herndon claims that one of the reasons why he didn't implicate the police officer was because he was afraid of the police officer. And that statement that he was afraid of the police officer was also in the miscellaneous file. And in an ironic twist in this case, the police officer was believed to be murdered before this case went to trial. And Herndon claims today that he tried to set the record straight.
Before Ledura's trial?
Yes.
And how does he say that happened? He went to the police or the prosecutor and said, "Boy, what I told you was a lie." How does he still wind up on the stand saying that Watkins did it?
Well, again, you'd have to hear Herndon's version of this, but because there's been different stories told over the years. But the bottom line is that Herndon was letting both the prosecutor and the lead detective know that he could not stand by his story. And obviously, he went on the witness stand and stood by that story implicating Watkins.
What did you say, T?
Perjured himself.
He perjured himself.
Yes.
Yes, absolutely.
But Herndon's version, and who would believe Herndon right now if he said the sky was blue? But Herndon's version is he tried to set the record straight and probably was, threatened in some way with, "Hey, we'll charge you with the murder unless you get up there and stand by your story." I mean, is that sort of what he's saying?
Yes. And Herndon actually officially, I think he signed his first affidavit as early as 1980.
Wow. And Ledura Watkins had that in 1980?
Yes, in fact, Ledura Watkins filed a post-conviction motion based on that affidavit. There was an evidentiary hearing held, and he was denied relief because the judge did not believe Herndon.
That's interesting. We hear that so frequently from clients who ask questions about recanting witnesses. And the reality is courts, at least in Michigan, look at recanting witnesses with an extremely skeptical eye.
That's right.
So even in this case with Herndon saying, I got on the stand and perjured myself, a court, and probably the majority of courts would say that's not good enough. You need more. Luckily, we had this hair situation. If he didn't, if it had just been based on Herndon's testimony, I wonder if he would ever have gotten relief.
Well, and also that makes the Brady file or the Brady material so critically important because there was information in the file that Herndon took a polygraph exam and failed.
Oh, interesting.
Prior to the trial. And in fact, the lead detective, when he was testified in front of the jury that, in effect, he believed Herndon and suggested that Herndon taking the polygraph was why. So he implied, the lead detective implied
Wow.
at trial.
So he's holy
So
smoke.
he bolstered the
Vouching,
credibility
right.
of Herndon by, again, we all know that polygraph results are not admissible
Right.
at trial,
Right.
but through the questioning, I believe the question was something like, from the prosecutor to the lead detective, something like, something about the gist of which was something about, why do you believe him, or what independent information do you have about Herndon? And
That didn't
he
draw an objection?
there I don't remember if there was an objection, but I know that the lead detective,
Right.
Detective
Oh,
Schwartz, testified. And again, it's not a nice, clean sentence like, I believe Herndon because he took a polygraph. But the way his testimony came across was two things. One is he strongly suggested to the jury that Herndon, in fact, took a poly. And by his answer, he suggested that he passed, which clearly he did take a poly, but he failed.
Jesus.
With do you think that this issue of, I know you have used the phrase incentivized witnesses who are not necessarily getting money but are getting some sort of fantastic deal or immunity, do you think that is a problem that is more pervasive than just in Ledura Watkins' case?
Well, it's a huge problem, and in fact, Ledura Watkins' case is a great example to show why. Because the jury in Ledura Watkins' case knew that Travis Herndon had received immunity for the murder, and in fact, during the voir dire, they spent a lot of time talking to jurors about that. What the jury didn't know is that there were other incentives or information in which the police and prosecutor assisted Herndon that was either in the Brady file or came out later. And those things included both the prosecutor and the lead detective going to another judge and discussing another charge that Herndon had pending. That did not come out at Ledura Watkins' trial. Ledura Watkins had a carrying a concealed weapon charge around this time. So sometime between September of 1975 and the time of the trial in 1976. He was never convicted of that charge.
Do you mean Herndon had the CCW?
Yes.
Okay, because you said Ledura Watkins.
Oh, sorry.
So just
No,
wanna be
sorry.
clear. Okay,
Herndon had a CCW charge pending during this time frame. So while there's not definitive proof that those charges were never prosecuted or finalized, so we don't know what happened with that. And then in the Brady file, there was a letter from the prosecutor to the Michigan Department of Corrections asking for Herndon to be protected during his incarceration. And this letter was sent, I believe, the same day Ledura Watkins was convicted. So while the letter was arguably post-trial, obviously the prosecutor and the lead detective were engaged in a variety of activities before and during Ledura Watkins' trial to assist Herndon. None of the things that I just described were ever before the jury.
And that is a violation of Brady because it's not just the explicit promises, but also the implied promises. That's how folks have tried to get around it, right? By not saying, I will do this for you, but implying that they will. That also needs to be disclosed, and frequently is not.
Is this prosecutor still practicing? Do we know?
The prosecutor is a named defendant in the civil lawsuit.
How about the detective?
I believe the detective is deceased.
When you got relief, were you in a courtroom, or did you get an opinion? Tell us about that.
This is probably, for me, the most amazing exoneration process-wise, because obviously we had to amend the 6500 motion, and we had very little time to do that because the case had been reversed. We were not officially Mr. Watkins' attorney. Just to diverge for a second, we had actually reviewed Mr. Watkins' case around 2006, and we made significant efforts to locate the hair evidence or any other biological evidence that was collected at the scene, but we were unable to locate any evidence. So we actually closed this file. individuals were reaching out to us.
So you close this file in 2006 because you can't find the evidence the forensic evidence that you think you would need to exonerate him. Again, how does he come back to you?
Yes. So
that's fascinating.
So
right?
yeah. So Mr. Watkins is a really amazing man. He is such a good advocate for himself, and he, people believed him. And I clearly remember reviewing his questionnaire, his very first questionnaire, which he would have sent to us sometimes, in the 2000s, 2003, 4, 5. I remember very clearly reading his questionnaire and thinking, if half of this is true, he's innocent. And yet our office typically has focused on post-conviction DNA testing. So when we couldn't find the evidence and we didn't really have any new evidence, there had already been an evidentiary hearing on the Herndon recantation, we closed the file. So fast forward in early 2016, we had a number of different folks reaching out to us saying, Mr. Watkins is in the Court of Appeals. He's trying to get into the Supreme Court. Can you help him? And I agreed to reopen the file for the limited purpose of looking for the hair evidence again, because we didn't have proof of destruction. And meanwhile, Mr. Watkins is going through the Michigan legal system on his own. And so...
Can I interrupt you for
yes,
a minute?
Of course.
To be clear for our listeners, you get how many prisoners are requesting your help? It's not just you're getting a dozen requests. I mean, you're just getting bombarded with requests, right?
Yes. So since 2001, we've screened over 5,800 cases.
Wow.
The fact that you remember his case, I think, goes to your great brain, but also to really the significance of the issues, that you remembered his case of 5,800 enough that you can recall it.
Yes, and I have a handful of those cases, and sometimes, we can't help that individual. At the time Mr. Watkins wrote to us, the FBI hadn't disavowed hair comparison. And frankly, we were not focusing on other types of new evidence in our work. We were focusing on, is there biological evidence that's material to the identity of the perpetrator that we could test? Because again, innocence projects, all innocence projects, we have limited resources to do the job that we need to do. But I see cases every day, maybe not ones as stark as Mr. Watkins in terms of, seeing just the questionnaire. But we see many cases and screen many cases where we're very troubled by the facts that led to the conviction. But either there is no new evidence that we see, which we would either pursue or refer, or we cannot find the biological evidence that might be tested with today's technology.
It's really heartbreaking. We get a lot of prisoner letters as well, and we'll look, at what they send us. And a lot of times, again, if from a resource perspective, we can't help them, but also we'll look and say, just as you did, right? It sure looks like you're innocent, but at this point, it's not about someone not making an objection 20 years ago, or it really has to be very significant to get that relief.
Yes, and we're really fortunate right now because we are now benefiting, and this just became official in the last week, we're now benefiting under 4 Department of Justice grants. So we have 2 grants where we are working directly with the Wayne County Conviction Integrity Unit to screen forensics type cases like this, as well as to obtain post-conviction DNA testing. And then we have similar mirror grants with the Michigan Attorney General's office, which, as you know, is in the process of developing their own conviction integrity unit. So these additional resources will allow us to spend the time and effort to look at these forensic practices more critically, which is amazing.
I mean, Ledura Watkins isn't the only person in prison based on flawed hair comparison.
No, there are probably hundreds of thousands of people, and that's correct. So going back to his case, though, and how we got involved, we were admiring Mr. Watkins' legal prowess from afar a bit. So we had reopened the case for the limited purpose of trying to see if we could find any hair evidence. And my staff attorney came into my office the day that Mr. Watkins won the summary reversal. And again, there are a couple of things in leading to his exoneration that I'll never forget. So he's standing in my doorway and he tells me, Ledura Watkins just won his case,
Wow.
and the courts remanded it, and he just stood there, the staff attorney, and I looked at him and I said, "You know what I'm going to say? We're opening the case." So it was our first sort of forensic case in the sense that we knew that we would still continue our efforts to look for the hair, but we knew that we had to jump in immediately and challenge the forensics. So that was there are several miracles here. So that's kind of the first cool thing that happened. The second touch point was Mr. Watkins had not raised the FBI standards. He did not have an affidavit in his last 6500 motion that went to the Court of Appeals, that went to the Michigan Supreme Court. So I reached out to the Wayne County Prosecutor's Office and asked if we could have additional time to amend his motion. So under the court rule, you can amend your motion, and the language on the court rule is amend and supplement. That's what I asked to do. Yes,
Nice.
thank you.
Good move.
So to the Wayne County Prosecutor's Office's credit, they agreed and allowed us to have more time to amend and supplement. And supplement we did, which is we obtained the affidavit from an expert, and we challenged the hair analysis. So to kind of come full circle, there was the Brady claim, which also included, that the fact that this newly discovered evidence was newly discovered impeachment evidence of virtually all of the witnesses that the government had called, right?
Right.
So we had that issue. We had the ineffective assistance of counsel claim, and we had the hair evidence.
What was the ineffective assistance of counsel claim? Because at least it sounds like the lawyer raised the issue of the hair,
Right.
and probably sought discovery and just didn't get it. Was there another error that you had identified?
No, Mr. Watkins had raised that issue on his own. And in fact, when we amended our pleading, I did not feel personally that that was a strong issue,
Right.
at least in terms of success.
Mm-hmm.
So we kept the issue, we preserved the issue, but we were really focusing on the Brady material and the hair comparison. Because the other thing we discovered, by the way, in the through our investigation and through the miscellaneous file, it's just a really long story, but to try to keep it short, was that we discovered that the lab report that was turned over to the defense was likely not the full report, and that there was some questions about the dates of the report. So very quickly, it appeared from reading the full report that the analyst had concluded that these hairs were similar to Watkins before he actually had taken the known sample from Watkins.
Oh my God.
my gosh. Talk about a twist. It's like a movie. Marla, who's going to play you, right?
I'm playing myself in the movie. That's what I always say. That's my story, and I'm sticking to
I
it.
was thinking, what's her name? Charisse Theron or
Oh, yes, I'll take her.
Yes,
whatever that actress's
whatever.
name is.
I
Right.
just saw her very briefly on a late night talk show, like walking onto the stage, and I said to my husband, "Wow, she looks amazing." So I would be honored for her to play me. That would be perfect.
That's right. Oh,
Yes. So what ended up happening is we amended our pleading, obviously, and then this is the third touch point. This is like we spent the entire Christmas holiday working on this. We filed it, I believe, late December, early January, and we were waiting to see if the court was going to order the prosecutor to respond, because under a post-conviction motion, they don't have to. And we were waiting to see what the judge was going to do with the amended 6500 motion. And I received a call from the chief of the appellate division of Wayne County. And I believe almost his first words were, "I'm sure you would be interested or happy," or something along those lines, to get your client released. And I was literally like dumbfounded on the phone. Like, the conversation was, he was calling me to tell me that he was wanting to have a conversation with me about Ledura Watkins' release.
Wow. at this point, had you met Ledura Watkins face to face?
Yes, we had
Okay.
met him actually multiple times. So,
So you have a good relationship with him, like a close relationship, and then you have a guy calling you saying, "Let's talk about him being released."
yes, and so at the end of that conversation, I actually had to ask for a little bit more time because I needed to go see Mr. Watkins and prepare for his release. So we arranged a court date with Wayne County, and I pulled my whole legal team together. And Mr. Watkins was in, I believe he was in Jackson at that point, and we all went down and told him that Wayne County was going to stipulate to the new trial. They wanted to write the stipulation, and their entire stipulation was focused on the hair comparison. And I think that was for obvious reasons. They
Right.
didn't want to have a court order talking about Brady material. They wanted to have a nice, clean break in this case. And they wrote the stipulation. We made some minor adjustments to it, and we had a court hearing.
Tell us, but how did you tell him? Like,
Right.
what's his
Words.
reaction? Right,
The
because at
words.
this time he
What do you
spent
say?
right over 40 years in prison for a murder he didn't commit. I mean, how do you tell someone like you're getting out?
Yes, I think when he saw all of us assembled, because there were quite a few of us that went on the prison visit, and I don't always go on the prison visits, he probably figured it's either really good news or really bad news. But he was very. You could tell he was really nervous. And when we told him, I'm sure he was in shock. He put his head down. He was very emotional, and I don't even think it really sunk in by the end of the visit. I mean, we stayed for a while and we talked about process and who we should contact and how this was all going to work. But he was completely overwhelmed. But one of the things that I notice with our clients is they do believe it's going to happen. They do believe it's going to happen. And that's a theme that I think you may have heard Mr. Watkins talk about, that, to have the fortitude to fight for almost 42 years and not give up.
And to
I
keep
think
that hope up
yes.
during that whole time.
And,
It's just amazing.
again, Mr. Watkins has lost so many things over the years.
Oh,
Both
yeah.
of his parents died. He was 19
Oh, wow.
when he was convicted. He's lost so much in his life.
Most of his life.
Yes, most of his life. But he's a very resilient man, and he will tell you much better than I can, that, maybe that's all you have left, right? Maybe
Right.
all you have left is hope.
Mm-hmm.
Right.
You've lost everything. And if you're in prison wrongfully, and in this case, Mr. Watkins had nothing whatsoever to do with this crime, you must, to keep your little candle burning, you
Mhm.
have to believe that eventually that's going to be figured out. Because if you can't believe that, then, what's the point?
Mm-hmm.
So he's a very tenacious,
Strong man.
strong
Yeah.
man, and I admire him tremendously.
Absolutely.
I remember attending the black tie event when he spoke, and I thought it was fascinating that his girlfriend at the time stuck with him, and she was there at the dinner. All those years waiting, that warmed my heart.
42 years to wait as his girlfriend. I mean, I don't know if Jeff would wait for me if I was late on the bus. I don't know that he'd stick around that long.
Right.
Wow, that's incredible.
Yeah, and he so kind. He wasn't bitter. Smiled. I think that permanent smile in his face, wider and bigger than anyone else's in the building. So yeah, it was just touching to see how grateful he was to be outside.
That's amazing.
Right?
Because I'm gonna hold a grudge.
Right.
So
and
I am not
and
that
she
strong.
will too. Lizzie will. I'll attest to that. Right?
I would be bitter. So I just can't imagine. He's just an amazing man. That's
One of the things that I think was really interesting that he shared about what keeps him or what kept him going was he said on more than one occasion that music played a huge role in keeping him grounded throughout the years. He was really into like jazz and blues music when he went to prison, and he tried to really maintain that and stay connected to music. He's also said he tried as much as possible, and it was almost impossible because he lost most of his family members. He only had 2 cousins at the time he was exonerated that he knew well enough for us to reach out to for his court hearing. We didn't know exactly where he was going to go because he had lost family. But in addition to music, he often says that he tried as much as he could to stay connected to the outside world, whether it was a lot of it was through watching television, but more in a participatory way, oh, I'm really following, this sports team, or, I'm really interested in what's going on in the world. So he had to make an effort, because it's not just the fact that you're doing time for something that you didn't do, but you're not in a healthy environment. You're in a very negative environment.
When you go to the prison, you tell him this is happening, and then he gets transported to court. Is that what happens? A judge releases him at that point in time? Tell us about that. And that's a movie moment. I mean,
Right.
It really is.
Right.
Yes. So I believe that it was about a week after we told him that he was actually released. So it took, we had a lot of paperwork to do and arrangements to make. And we knew going into the court hearing that Wayne County was going to not only agree to the motion for new trial, which is a phenomenal result in and of itself, but that they were also going to move to dismiss the charges. So we knew that Mr. Watkins was going to be released on the date of his court hearing. And the courtroom was packed with supporters, many of whom had worked on his case over the years. Many were associated with the Cooley Innocence Project. We had, again, maybe one of the most amazing court hearings I've ever participated in. Bruce Morrow was the judge. He allowed every single person in the courtroom to introduce themselves and say how they were connected to the case. He got Judge Morrow, during the course of the proceedings, got down from the bench and handed me a Kleenex because I was crying.
Oh, of course.
He asked personal questions of Mr. Watkins and asked Mr. Watkins, to speak. And Mr. Watkins, you've heard him speak, he spoke very eloquently, and they had almost like a very intimate conversation. And Judge Morrow was giving Mr. Watkins more than a moment. And it was a really amazing experience.
That's incredible.
It sounds like the judge was visibly moved by what was occurring. And you said you were crying. Was there other people? I can't imagine there'd be a dry eye.
Well, I usually cry. Sometimes even on a good day. I mean, it's very emotional, obviously. Right. This is not, this isn't a typical day in the Cooley Innocence Project, right? So when one of our clients is getting released, it's a very emotional day. I was trying to compose myself, of course, but I had tears sort of streaming down out the sides of my eyes. I wasn't, so the judge noticed, and he came down off the bench with the Kleenex box, which was so amazing and touching. Of course, Ledura was very eloquent in his conversations, but Judge Morrow remembered Ledura. He remembered him when he had filed previous motions. He had remembered him when Judge Morrow had gone into the prison system and spoken at an event for prisoners. And they had had a conversation. And Judge Morrow seemed to remember all of that. And I think, sometimes judges, particularly circuit court judges, I think they see cases sometimes. Now, he wasn't the original trial judge, but I think judges see this over the years, and they're not in a position to do anything, right? The right facts, the right lawyer, the right information has to come before the court. So, I'd like to think that it was a very special day for Judge Morrow as well. And he was very gracious and gave us, he could have done this very quickly and out the door, because Mr. Watkins was not released in the courtroom. He was released at the county jail. So there was not necessarily a need to do that, but it was very much appreciated and frankly unexpected. We did not expect that. The judge was the one that looked around the courtroom and said, "It looks like there's a lot of people here." And I believe he asked who's here for this case, and virtually the entire room was for the case. And it was the judge that, as the judge is in charge of his or her courtroom, the judge that allowed this exoneration hearing to be one of the best things I've ever participated in as a lawyer.
What a remarkable judge to set it up that way. And as you said, he could have just been like, okay, you're out in 60 seconds, but to really give that closure in a way and
right.
celebration. I know that sounds crazy, but after 42 years, Ledura Watkins earned the right to stand in a courtroom and say and speak for as long, quite frankly, in my opinion, as he wants. And for Judge Morrow to offer that to him is really remarkable. And I think quite a testament to him as a man and as a judge.
Yes, it was a beautiful experience, and we don't often experience that in the courtroom.
It had to have been just an absolutely great day for you, because not only is it like emotional because you've been working on the case and you've gotten close to him, but to see all of your hard work finally, be rewarded, really.
Yes, and every single exoneration that I've been a part of, there are those touch points, and there are actually miracles along the way. So obviously, I don't want to downplay the legal work. It's huge, and it wasn't just the work of the Cooley Innocence Project. It was the work of Mr. Watkins himself. It was the work of the many lawyers that he had over the years that tried to fight the fight for Mr. Watkins. And it all culminated, far too late, but it is a really amazing day. At least in Wayne County, your client has to be released from the jail, which is a little frustrating because you have to wait a really long time. But obviously, and also only attorneys are allowed to go into the facility. So again, we had a large number of supporters standing outside the jail for quite a long time. We're used to that on Exoneration Day. We feel it's a very small price to pay. It's totally worth it.
Absolutely.
But there's no better feeling than that moment when you are walking out with your client. Sometimes you're holding his hand. Sometimes, as in this case, we want them to be with their family and to have his family. And for my students, many students worked on Mr. Watkins' case. Many students gave up their Christmas break to come into the clinic when at a time they weren't required to write these briefs. And if I may, I just want to give a special shout out to Professor Bradley Charles at Cooley, who is one of our legal writing professors. And he came in and helped with editing of the 6500 motion and was pretty much, a lifesaver for me, because we're a teaching clinic. So we were trying to pull together some very complex legal issues in a relatively short period of time. And I'm very proud of the legal work that my team did. It's always a team effort. But it's, yes, always a really amazing day, rain or shine, when your client walks out and is exonerated.
I'm tearing up thinking about it.
It's like sticks in a bundle, right? You become unbreakable. And all the people along the way, as you said, all the lawyers who helped out the students who, we know that, right? You work on the weekend at night and you get that tangible result. At the time he was released, he had the unfortunate honor of being the longest serving prisoner who was exonerated, correct?
Yes, in Michigan.
In Michigan.
Yes. And there were individuals that had served longer, but I can't remember who the individual is in another state, but many of those individuals ultimately were paroled
Right.
and then exonerated after they were on parole.
For Ledura Watkins, he was sentenced to life in prison with no possibility of parole, correct?
That's correct.
And this was the avenue for him. Do you stay in contact with him? What's he like now?
Yes, I stay in contact with him. Ledura was really fortunate because the Wrongful Imprisonment Compensation Act was passed, I believe, either right before or right after his exoneration. And while the application of that law has been abysmal,
We know.
the companion bill to provide the same services to exonerees as parolees has been very beneficial. And so what Mr. Watkins did is he immediately tapped into those services. He went back to school
Good.
and received some training, and they liked him so much that, he worked for the school for a while. And he, again, I really say that a lot of his positive adjustment is based on who he is, not what we've given him, because we've given him basically nothing, right? But he's 62, 63 years old. He's a very mature man, and he's a very mature person, and he's very comfortable in his own skin and who he is. And we can't say that about a lot of people we know. So he just, he's struggling. He's working now, I believe, for the city of Detroit. He's working like 6-7 days a week. He's working physical labor, and he shouldn't be doing that. But he's grateful for what he has, and he's a role model to me. He's a role model to our students. He's a role model to anyone who would meet him, that he has come out of these circumstances certainly not unscathed. In fact, deeply hurt, deeply wounded, and incredible losses, losing both his parents. He has said that he believes that his wrongful conviction contributed to his parents' death. And our first exoneree, Ken Wynemko, is also convinced that, when your child is being locked up for something that and they know they didn't do, that has to be one of the most heartbreaking life experiences anyone would ever have to deal with.
Well, it's something we did a story about Kim Tomasic, who was the wife of Dennis Tomasic, who spent 9 years in prison. Certainly not 42, but I think 9 minutes of being wrongfully convicted is too many. It was something she said she thought about every day, every night. Not a day would go by. It wouldn't matter the event, a wedding, birthday. It was always there. And I agree that stress and that sadness for what's happened to your loved one is always there. Luckily, Ledura Watkins had you and your team. Where does that come from, Marla? Because I know you. These are not short days. I mean, where does that drive for justice come from? For a little girl? I mean, was there a bully on the schoolyard? Or is it just innate? It seems like it runs through your DNA.
I remember exactly where it came from. So I was in high school, and I was in like a social studies class, and my teacher was talking about corrections. And I was fascinated. And the class let out, and I went out into the hall, and the teacher was standing there, and I said, I'm really interested in this corrections thing. I just, working with prisoners sounds like something, I'm really interested in. So you have to have the context here. So this is in probably 1976. My social studies teacher punched me hard in the arm.
On purpose?
Yes. That's why I needed to say the year, because
Okay.
he would have been canned.
Statute of limitations.
And he said to me, "You need to be tough if you want to do this kind of work." And that was very eye-opening for me. But that started my journey in having an overall interest in the criminal justice system. And for some odd reason, I have no idea where that came from, but just working with prisoners. And I was just really lucky in law school. I actually was a student in a post-conviction clinic. I ran an inmate assistance program in a local jail. I used to go on the catwalk and tell tell the prisoners if they did not have at least a towel on, I would not be able to give them any legal advice.
Who would think that, right?
Right.
When you're in law school, I'm going to have to tell clients,
Yes.
cover up your penis. We don't want, I'm not,
Exactly.
Right.
I'm not here to see that.
And so I've always enjoyed post-conviction work and working with prisoners. I've always enjoyed going into the prisons and meeting with my clients. And so if you fast forward to around 2002, when I first became involved in the Cooley Innocence Project, in many respects, I was home. That's where I was meant to be, right? So for me, it personally, and as a lawyer, I don't have a strong feeling about guilt or innocence. I believe that every individual should be respected, and that that everyone is expected to be treated as a human being, and that we need to respect human dignity. And I've worked with clients who have done really heinous things, but I have to say I've never met a client over the many years of my practice that I couldn't find something good about. So I think that's where it comes from. And obviously, I didn't have a twinkle in my eye about DNA or wrongful convictions in the late 70s when I went to high school. And frankly, even when I was in law school and I was doing post-conviction work, right? We were raising ineffective assistance of counsel claims and confrontation claims. And I didn't know, that my career was going to lead to this. But I'm very grateful that it did. And, I get up and do this because I believe in it.
We're all grateful
Yes,
it led
indeed.
to this. Everyone should be grateful, Marla. What you and your team do, you change lives, and not just Ledura Watkins' life, but you help
many
shine a
others.
light on the system and the flaws in the system that so many people don't recognize. Boy, we're so grateful that I'm not grateful that your social studies teacher punched you in the arm,
Right.
but I am grateful that you had a class on corrections that was that spark which led you to this journey. Thank you so much for being with us today and telling the story of Ledura Watkins and your team and everyone who is involved in exonerating him. He's a remarkable man and you're a remarkable woman, and we're so, again, thankful for all of you.
Well, thank you, Mary. And if I could just add one last thing.
Oh, of course.
I think it's really important for the listeners to know that most future lawyers are not going to be Innocence Project lawyers, but the lawyers or the law students that I'm training are going to be well-prepared defense lawyers, ethical prosecutors. The students that I'm training are the future of the criminal justice system, and I can't think of any better training ground for a law student who wants to do prosecution or defense work, or frankly policy work, than working in an Innocence Project. And I'm very, honored to be able to, have that teaching component as part of this very challenging work. And I think that the future is really bright, because I can tell you I have a number of alumni who are now prosecutors, and whether they were part of an exoneration or not, they'll never forget the cases that they reviewed in the Innocence Project. And I think that it helps them really learn how we as lawyers actually do hold the life of our clients in the palm of our hands. And again, many of the clients that or potential clients that we work with, we can't help. And that's heartbreaking for me, and it's heartbreaking for these future lawyers, but it makes them better practitioners. So I think that, the Innocence Project work in general is well beyond exoneration. And I know you all know that, but I think it's really important for listeners to know that, trying to make something positive out of these wrongful convictions. Ledura Watkins is doing that by who he is, the way he lives each and every day of his life. He's a role model for all of us. And our goal here has to be learning the lessons. What are the causes and how can we fix them, both as lawyers and as a society? So thank you for having me.
Thank you, and amazing final words. Boy, you're really changing the world, Marla, one day at a time. That's
right.
fabulous.
Again, I'd like to play myself in the movie, but Charlize, if you're listening,
That's right.
I might
That's
be
right.
willing to step aside if I can look as good as you.
That's right.
Thanks, Marla.
Thanks
Thank
so
you.
much, Marla.
Once again, a big thank you to Marla for being with us today. Make sure you're following us on our Facebook, Twitter, and Instagram accounts. You can find links to those pages on the Buzzsprout website that we have for our podcast. And we're happy that you're here with us. So keep an ear out for our next episode. It should be up the next 2 weeks. Have a great day.